Unit 6. Acquisition of real estate by foreign citizens. Foreigners can purchase a real estate in the Republic of Croatia, that is, acquire real estate ownership if they are citizens and legal entities of the states with whom there is reciprocity in obtaining the right of ownership of real estates in the Republic of Croatia and with the prior consent of the Ministry of Justice of the Republic of Croatia. Citizens and legal persons from EU member states can acquire the right to property ownership under the assumptions applicable to the acquisition of the right of ownership for citizens of the Republic of Croatia and legal persons with headquarters in the Republic of Croatia, with the exception of the real estate in excluded areas such as agricultural land regulated by a special law. The Agricultural Land Act stipulates that holders of property ownership rights on agricultural land cannot be foreign natural or legal persons unless otherwise provided by an international agreement and a special regulation. Given that no special regulation or international agreement stipulates otherwise, for now, foreign legal and natural persons cannot acquire the right of ownership of agricultural land in the Republic of Croatia through legal transactions. Pursuant to the provisions of the Treaty on the Accession of the Republic of Croatia to the European Union, citizens of the European Union cannot acquire agricultural land from the date of accession of the Republic of Croatia to the European Union for the next 7 years with the possibility of a ban for another 3 years. The granting of approval for the acquisition of ownership rights by foreign persons, excluding citizens and legal persons from the EU member states, regarding real estate in the Republic of Croatia shall be decided upon in the administrative procedure at the request of the party, acquirer. The procedure is conducted in accordance with the provisions of the Act on Ownership and Other Real Rights as well as the General Administrative Procedure Act. The application, in writing, is submitted directly to the Registrar's Office or sent by post to Ministry of Justice of the Republic of Croatia, Directorate for Civil, Commercial and Administrative Law, Ulica Grada Recoverer 49, 10,000 Zagreb. The written application must be accompanied by the legal basis for acquiring ownership, sale and purchase contract, a deed of gift, contract of support until death, etc., the original or a certified copy. The proof of ownership of the seller of the real estate concerned, that is the extract from the land registry, the original or a certified copy, not older than 6 months. The certificate of the administrative body responsible for urban planning, according to the place where the real estate is located, on the legal status of the real estate, whether the real estate is within the boundaries of the construction area as envisaged in the urban plan. A proof of citizenship of the acquirer, a certified copy of the passport and the like, or a proof of the legal status of the legal person, extract from the court register, if the acquirer is a foreign legal person. In the case where the applicant is being represented by a proxy, the authorization must be submitted in its original form or a certified copy. If the applicant did not designate a proxy who will represent him, and he is abroad, he is obliged to designate a proxy authorized to receive documents and who has a residence permit in the Republic of Croatia. A proof of payment of administrative fee in the amount of HRK 35.00 according to Tariff Number 88, Item 1 of the Regulation on the Administrative Fees Tariffs. The administrative fee must also be paid for a decision regarding the request for consent to acquire property rights in the territory of the Republic of Croatia in the amount of HRK 70.00 and for any possible addition to the request, in case of missing documents, in the amount of 15,000 kunis. Information was downloaded in August 2018. The party will be invited to submit, within the due deadline, other documents, if they are necessary for the proceedings. Administrative fees up to HRK 100.00 can be paid in form of stamp duties, and regardless of the amount, fees may be paid through the e-fees system and on the prescribed account, or through a universal payment order on the account of the state budget of the Republic of Croatia. IBAN HR 12100051863000160. By entering the number 64, model, in the first field of the universal order. By entering in the second field of universal order the number 5002. In case of payment by a Croatian citizen with the number 5002, the OID should also be entered, and in case when the amount is paid by the foreigner, then the number 721 and OID must be entered after the number 5002. The applicant or his proxy, along with other documents, must also submit the proof of the administrative fee payment. The information on reciprocity regarding acquiring real estate ownership rights between the Republic of Croatia and other countries is listed in the following table,